I think the founders of the country recognized that the reason we needed a Supreme Court, we needed that third branch as a check, is not because they needed someone just sit there and decide things, but the Supreme Court was supposed to be that conservative, slower moving body that says, whoa, things are moving a little bit fast here. Let's take a minute. Let's really think about it. And then we will proceed.
So anyways, let's get on to segment one. This is the Roma recap of the Supreme Court. So tonight we're going to go over the recent Supreme Court rulings of this session, and let's take a look at the rulings that were made, why they're important, and what it means for the future of Americans in tonight's edition of Roma Recap. All right, so number one, we're going to go over Chevron deference. You ready?
Absolutely.
Let's go. All right, so Chevron deference is a legal principle that emerged in the 1984 Supreme Court case of Chevron USA Inc. versus Natural Resources Defense Council Inc., and it requires courts to defer to a federal agency's interpretation of an ambiguous or unclear statute that the agency administers as long as the interpretation is reasonable. So let's go ahead and get started today with our first set up. Let me get set up here.
What exactly is reasonable? That's the weird question.
I don't know. I guess it's one of those things. You know how when you get a job and you sign on the dotted lines and it says like, we can let you go for any reason without notice, something like that.
Oh, you mean that we can bend you over for any reason without notice clause? I got you.
Yeah, basically. But anyways, let's tune in here. I believe what is this? This is Yahoo Finance.
Supreme Court overturned a 40-year-old precedent known as the Chevron deference, which ruled the courts should defer to a government agency's reading of any ambiguous laws or statutes rather than interpreting it for themselves. So here to explain the potential ramifications of this ruling, particularly on the financial world, we're going to welcome in Leah Dempsey. She's Brownstein's shareholder and co-chair of Financial Services Practices Group. Thank you so much for being here with us, Leah. I want to start just on the kind of interpretation of this news. So as a reminder to folks, this is the idea that, there were limitations within the degree to which lawmakers and political appointees could interpret certain laws. They would defer to experts on each individual type of doctrine and decision. This used to be a bipartisan issue. What changed, Leah?
Yes, well, so interestingly, this came out under Justice Scalia during the Reagan administration in the 80s. It was an interpretation of the Clean Air Act. But over time, I think the conservative wing of the court thought that it became a separation of powers issue where, Congress wasn't necessarily delegating certain authorities to the agencies, but the agencies were seeing a silent or ambiguous statute as the opportunity to promulgate rules that may align with a certain political party.
Oops.
Which ruled the court.
Sorry,
that what was changed, my fault.
Leah? I meant to pause it. So essentially, what I see here are the issues of other people outside of our three-letter agencies coming in and making decisions for them that to benefit just them, the government themselves, and not the people. When you look at unelected bureaucrats, when you look at big business and a lot of these big-time corporations like tobacco and pharma and things like that, of course, they're going to want to have a say in how these things work. But you have, these big corporations on one side, but you have nobody on the other making the defense or being able to make the defense because they quite frankly just don't have the knowledge base or are in or don't have the ability to know as much as those agencies do.
So something she said, it used to be a two-sided issue. Everyone understood that there was problems with Chevron, and over the last decade, things have changed. You know what's changed? The understanding that unelected bureaucrats get to make these decisions is scary.
Mm-hmm.
And when you're on a certain side of the political spectrum, you want daddy government to hold your hand and make all those decisions for you. You don't want to, for whatever reason, put those uh, representatives that you elected into a position of making a decision, apparently, because why would you want that? Instead,
Mhm.
you want these unelected people, and I can't fathom why anyone would want to do that.
Well, it's not, well, we don't want that, but as far as the establishment is concerned, it's not like they write these laws and bills themselves. You know?
No, of course not.
Of course not. Because the Chevron doctrine, I mean, it's been a cornerstone of the administrative law for nearly 4 decades. And it allow agencies like the EPA, FDA, and like FCC to interpret them and implement congressional statutes, giving them like very considerable leeway.
Oh,
Very
it was Congress, and by extension, the court itself, handing over legislative power effectively to the executive branch.
exactly. Yeah, so they have ultimate authority coming from the top down. So but we're going to get into that when it comes to the executive branch on the next part, but we'll get to that in a second. Let's go ahead and continue the video.
Issue where Congress wasn't necessarily delegating certain authorities to the agencies, but the agencies were seeing a silent or ambiguous statute as the opportunity to promulgate rules that may align with a certain political party. And has been a lot of litigation on this issue. I think over 1,800 cases have 18,000 cases have cited the Chevron deference, and over time, different courts have looked at this differently. Really, the Supreme Court in recent years has not necessarily relied on Chevron as much. They've relied on a new case, the West Virginia versus EPA, which introduces a whole nother issue called the major questions doctrine. But this ruling is significant and will have a number of ramifications for the financial services industry.
Okay.
We didn't even think about that. What about the financial services industry?
Well, it's funny because most people that would listen to you would listen to me only care about the 2A implications, right?
Right.
They don't understand that Chevron impacts a wide array of things.
Mhm.
It impacts every 3-letter agency we have. It impacts all the cabinet positions, because now they have to get approval from Congress to make a law or a policy that's going to affect everyone, that they're going to have legal proceedings around.
Exactly. Right. So let's get a little bit of an idea of what's going on behind closed doors. This is from SCOTUS blog. Supreme Court strikes down Chevron curtailing power to federal agencies. In a major ruling, the Supreme Court on Friday cut back sharply on the power of federal agencies to interpret the laws they administer, and ruled that courts should rely on their own interpretation of ambiguous laws. The decision will likely have a far-reaching effects across the country, from environmental regulations to healthcare costs. By a vote of 6-3, the justices overruled the landmark 1984 decision, which gave rise to the doctrine known as the Chevron doctrine, or the Chevron deference. Under that doctrine, if Congress had not directly addressed the question at the center of a dispute, a court was required to uphold the agency's interpretation of the statute as long as it was reasonable. But in a 35-page ruling by Chief Justice John Roberts, the justices reject the doctrine, calling it fundamentally misguided. Now, of course, 40 years ago, it wasn't misguided. Because things made a lot more sense back then, and there wasn't the internet to
Well,
pull people back and forth.
Back then, science was science, and you could trust an expert, right? No, you couldn't. But
right?
it at least recognized that there are experts out there, and they had to be credentialed to be considered an expert. Nowadays, because of the internet, everyone's an expert in everything. Did you know that I am an expert in AI, law, literally everything on the internet? Because guess what? I know everything, or so I want people to believe.
Yeah, because if it's on the internet, that means it's true, right?
Hey, it doesn't have to be true. I just have to make you believe that it's true.
Exactly. So, what does this mean in the short term? Because the agencies may face more legal challenges with the regulatory interpretations, but the courts will scrutinize their decisions more closely, which could, slow down the regulatory process. But that's how it's supposed to be. It's kind of like the president when it comes to impeachment. You're not supposed to easily impeach the president. It needs to be a majority decision for a reason so that it's not weaponized and used against the American people, or in this instance, the president.
I think, and this is something we talked about previously, Roma.
Mhm.
I think the founders of the country recognized that the reason we needed a Supreme Court, we needed that third branch as a check,
Mhm.
is not because they needed someone just sit there and decide things, but the Supreme Court was supposed to be that conservative, slower moving body that says, whoa, things are moving a little bit fast here. Let's
Mhm.
take a minute. Let's really think about it. And then we will proceed.
Right.
And that never has that been more important than these days where things are happening 24 hours a day, 7 days a week, all over the world. And nobody can keep pace with everything coming through Congress.
Right. So in the long term, we could see a shift in how agencies draft and implement regulations and might adopt more cautious approaches, relying on heavy, uh, you know, uh, unambiguous statutory language. It
Oh,
could also
absolutely.
yeah, but in the end, what the Supreme Court is saying is that Congress, you need to step up and do your job and stop sending through all of these different packages of BS where like nobody looks through it. They're just like, yeah, this looks good. Just sign it off. Let's go. And then nobody
You mean
really knows how the law is interpreted.
you mean they're supposed to work together?
That's correct. But for some reason, the last 20 years, something happened. I don't know. But to end this first part of the segment, what does this mean for the FBI and the DOJ?
Hopefully they go away forever.
Mm.
They're not, but I mean that's the hope.
Right. Or at least, but when you think about it, when it comes to like the January 6th cases, is it possible when it comes to the DOJ that people can now step up and say, okay, well, now the interpretation's on us, not on you, to decide if whether it was breaking and entering or whatnot. And, it's up to you, the DOJ, to come in and tell me if whether I broke a law or not.
Well, I think it's going to have a profound impact on the DOJ just because in every court case that comes through, every judge is going to have to sit there and take a moment and think about, okay, here's the statute. What's the interpretation from Congress? What's the interpretation from our parenting group, the DOJ? And where is that line?
Mm-hmm.
I think we're going to see some major changes in sentencing and rulings throughout the court system for several years to come. There's going to be more cases that come through now.
Exactly. All right. With that being said, let's move on to the second portion of this segment, and that is the presidential immunity case. Oh, man, we had a lot of fun with this week. That's for sure.
All hail the king.
All hail the king. Yeah, this is so stupid. I can't believe people actually think that. But anyways, let's get to it.
Earlier this week, the U.S. Supreme Court ruled former President Donald Trump has some immunity in the federal case, accusing him of trying to overturn the 2020 election. President Joe Biden said the decision sets a dangerous new precedent. So just what is that precedent? Casey Decker with our Verified team breaks down what we know.
In the most anticipated ruling of the year, the Supreme Court decided Donald Trump has some immunity from criminal prosecution for official actions he took as president. The 6-3 ruling complicates the ongoing case against Trump for his
correction, not just Donald Trump, but for every other president in the past, present, and future.
Well, it's not some immunity. It is a lot of immunity.
Mm-hmm. It really is. But let's finish. Let's see what they say, and then we'll play a little game.
Actions to overturn the results of the 2020 election. Critics of the ruling, including President Biden, argued it turns presidents into kings who are above the law. We got numerous questions from viewers about the ruling. Viola wanted to know, does the decision also give immunity to President Biden? Donna asked, does it give the president unlimited powers? For instance, could he postpone the election or bring back Roe v. Wade? And many people wondered about a hypothetical that was brought up repeatedly during oral arguments in the case. Is the president now allowed to order the military to assassinate his political opponents? So let's verify with these sources. First, does the decision give immunity?
Before he answers these questions, you want to answer these first?
I absolutely can.
All right, so I'll give you the first one here. So, Biden immunity. Does this also mean that Biden is immune from his crimes?
Absolutely.
He is. You know,
the same immunity that was granted to Trump, and it's not really granted to Trump, by the Constitution, is there. It hasn't changed.
Mm-hmm. Exactly. And just like, how can you not have the president have immunity, but you have governors and AGs and congressional members do? Like, does Congress not understand that this applies to them as well for the different laws that they put into place? Let's say they put in something that ends up, I don't know, killing 60,000 people. Do we now get to go in and criminally prosecute our representatives? No, of course not.
Well, consider this. You, me, anyone else goes to court, and the DA really wants you to say something. They really want you to either plead guilty. They want you to, give up information on someone else. They can grant you immunity.
Mm-hmm.
So is this really taking anything away or adding anything? No, we've had the ability to grant that immunity. And if a lesser court or lesser, what's they called, an inferior officer of the court can grant that immunity, how is it not possible that the president wouldn't have it?
Yeah, exactly. Because it wasn't like the same DOJ was trying to give Hunter Biden absolute immunity over anything he would ever do. He would have been,
don't even get me started on that. Hunter and Joe royally screwed that whole thing up.
Mm-hmm.
Hunter could have been off scot-free.
Not only would he have been scot-free, but he would have been the most powerful man on earth. Because they wouldn't be able to prosecute him for anything. Like, that's crazy. But again, you have to remember that there still are processes in place. So if he does something that's unconstitutional, he has immunity unless Congress revokes it from him.
So give an example of where Congress could say, "Hey, Joe, you just crossed the line."
Well, I mean, they did it to Trump twice, right?
Oh, they did. they didn't seem to do it to any of the other past presidents, which is weird and that's another thing. Notice who hasn't come out and given their opinion on this.
Mm-hmm.
All the living presidents before now.
Not a single one.
They don't want this. They don't want that immunity to go away. They all did things that could have been criminally prosecuted.
Mm-hmm. All right. Well, let's see what the answer is, shall we?
To President Biden. Yes, it applies to all presidents. The ruling says, quote, presidential power entitles a former president to immunity from criminal prosecution for actions within his constitutional authority. Second, could the president now postpone the election or bring back Roe v. Wade?
No.
Because so here's the thing. It was not within his constitutional authority to do so. Elections, for example, are determined by the Constitution. Roe v. Wade, it was a court case. That's not within his scope of influence. And it wasn't even part of the Constitution to begin with. How could anyone consider this to be a possibility?
Well, it's because there are. How do people not understand that there are three columns of government, and they all have their own specific responsibilities based on the Constitution? So saying that he's going to bring back Roe v. Wade, well, if that was a court case, that's the judicial branch. That has nothing to do with the executive.
Well, it's a combination of judicial and legislative, actually.
Yeah.
Because Congress has the ability to draft legislation, to even amend the Constitution itself. And it's weird. They haven't done that. Exactly. Why not?
Even when they had the House and the Senate, they haven't done that. Either side.
They're not going to either.
Yeah, but until the Constitution blows up, Congress still makes the laws, in the Supreme Court and the judicial branch. Will interpret the laws, because here's the thing: there is no such thing as a perfect law. There's no such thing as a perfect, like maybe except for pedophilia. Those things, those guys, people can go.
But see, that's just it. You said it right there. Congress writes the laws, the judicial interprets. What does the executive do? They apply what is determined to be the law. They enforce it. That is their role.
Yep. But now with Chevron deference, it severely limits the ceiling of what they can do. So
Yes.
I believe that the Supreme Court got both of these right, because not only did you give him more executive authority via the presidency, but you limited the amount of power that he has. So it's like it's broadened his spectrum, but you can only go so far. So that's what they did.
It's almost like there's a check and a rebalancing happening.
That's how it was made, but I don't know. I'm so tired of explaining myself on this part. But anyways, let's continue.
No. Giving the president immunity from criminal prosecution isn't the same thing as giving him unlimited new constitutional powers. Currently, most of the power for deciding abortion laws and running elections is held by states. If the president tried to order states to change the election date or allow abortion, there's nothing in this ruling that says they'd have to listen to him. And a president can't just declare new federal laws. Congress still controls that process.
There it is.
And our final question: can the president now order the military to assassinate his political opponent? After all, he is commander-in-chief. Military action is within his official duties.
Thoughts?
The answer is actually yes, he can do this. However, the Uniform Code of Military Justice says if you receive an order such as this, you are not only allowed, but obligated to call it out and ignore it, because that immunity that the president has to give that order, in this case, does not extend to you actually carrying out that action.
Exactly. So, because it's exactly that. The immunity is on him. It's not on the people that he gives the orders to. It's not that. I mean, if you're in a international conflict and you get orders from the president to go take out this particular, that's within the scope of the military. All right. But when it comes to American citizens, on the other hand, nowhere in the Constitution does it say that a president can kill American citizens with immunity. Nowhere.
Now, what I'm interested to see, because I haven't seen this video that we're watching, I'm interested to see how they answer it, because, like I said, he has the authority, the ability to actually give that order, and he always has. It's just, what's their take going to be?
You ready to find out? Here we go.
But legally speaking, this question remains unclear. Justice Sonia Sotomayor argued in her dissent the ruling means exactly that. Quote, if the president orders the Navy's SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. But in his ruling, Chief Justice John Roberts said that dissent, quote, strikes a tone of chilling doom that is wholly disproportionate to what the court actually does today. Ultimately, the courts will have to decide on a case-by-case basis what specific presidential actions are protected by immunity. With your
so I mean, Justice Sotomayor, I mean, that's just fear-mongering. That's what you're doing right now. You're fear-mongering to get the people in the country, in the press, to say something about it. Which is, I don't want to say that's that's impeach worthy. I mean, that's dumb, but
but you know what wasn't said in this video, and you kind of started on it. The mechanism by which Congress and the DOJ have to then take this step forward and saying, all right, the immunity doesn't apply here. We're going to impeach you because you turned a drone strike on American citizens domestically, right? You
Exactly.
gave that order, and that is a high crime. That's a treasonous act. We can punish you here. They'll impeach him, they'll convict him, and then guess what? Then he doesn't have that immunity, and it's been determined by Congress that he doesn't have that immunity. We can prosecute him.
Exactly. What does he think? He's a CIA?
Apparently, if it's Joe, he's old enough. He might actually think he is the CIA.
Yeah, right. But to end this out, where are the arguments on the CIA's immunity? Where are the arguments on all the stuff that they've done throughout all of history, the CIA history in other countries and also in our own?
Come on, AK. You know the CIA is a myth. It doesn't exist.
They don't exist at all.
They don't do anything.
No, they're just a figment of my imagination. All right, moving on. So the third and final case that we went over, I wanted to get away from like the politics aspect, and I wanted to jump into something that has pretty much been in the Supreme Court for nearly 100 years. I think there was something like 34 justices have gone over this particular case.
And none of them got it right.
And nobody got it right. And this is from, let's see, from Justia, the U.S. Supreme Court, justia.com. This is Texas versus New Mexico. And this is about the case that involves dispute over the allocation of water from the Rio Grande River among the states of Texas, New Mexico, and Colorado. The Rio Grande Compact, an interstate agreement, governs the equitable distribution of the river's water amongst these states. In 2013, Texas sued New Mexico and Colorado, alleging that the excessive groundwater pumping in New Mexico was depleting the river's water supply intended for Texas in violation of the compact. So let's get into it.
The Supreme Court has rejected a settlement in a water dispute involving New Mexico and Texas. In a 5-4 opinion, it ruled that the water sharing deal between New Mexico and Texas cannot go through because the federal government still has concerns about New Mexico water use on the Rio Grande. For a little context here, this all dates back to a 1930s agreement called the Rio Grande Compact, when Colorado, New Mexico, and Texas agreed to share water in the Rio Grande. Then about 2 years ago, Texas and New Mexico were looking at an agreement that would sidestep the federal government. Justices ruled the deal cannot go through and, quote, "We cannot now allow Texas and New Mexico to leave the United States up the river without a paddle," end quote.
That was cute. But anyways, yeah, so this has been going on for 100 years. Why? Okay, so I get it. So let's break it down here, because we move on to the next segment. So in Texas, all right, so it has the biggest population out of the 3 states. It has the least amount of jurisdiction because it's not where the river starts, and has the longest body of the Rio Grande bordering its land. I mean, New Mexico, I can understand, it's a very dry and temperament climate. So of course they're going to need, but how many people are in New Mexico?
Wait, New Mexico's an actual place?
Yeah, it's Mexicans that liberated themselves from Mexico.
That's where we're sending all. Never mind. I'm not going to say that.
Yeah, we're not going to go there. Strike. Yeah, no. And then of course Colorado, that's where I'm guessing the river starts because it flows down towards Texas. So
what was the population demographics 100 years ago when this compact was made?
Oh my God, who lived in Texas back then?
I mean, that's the real question, right? Because you can't predict 100 years out what the impact of your decision today is actually going to be. And the fact that this hasn't updated or changed for the demographics of those areas is kind of interesting to me.
Yeah, because I mean, I don't understand. Listen, we all need water. Okay. And we understand that that particular area of the country does not have a lot of water components to it. So, of course, you're going to have to, divvy up and figure out what's going on. But it's kind of the same thing with California. California had an issue with this a couple years ago, didn't they? With the Colorado River
Yeah.
in what's it, Lake Mead?
Yes.
Yeah, because they're the ones, because Lake Mead is what supplies all the power to Southern California and a lot
Yep.
of different other places too.
That also Hoover Dam.
Yeah, Hoover Dam. Exactly. So it's you haven't been able to figure that out in this amount of time, and I'm pretty sure the water has been depleted well beyond repair,
Probably.
at least now for the next 20-25 years, unless you put in heavy regulations. But Chevron deference changed that. So but
And
go ahead.
how much has California contributed? I mean, in either case, how much has either state contributed to actually making this workable financially? That should also have an impact on this. If California was spending all the money to upkeep Hoover Dam, all the money to generate that electricity that they benefited from, then yes, they have a leg to stand on. Where do you go? How do you make these decisions?
Well, I mean, I think, with Texas and California being the first and third, they generate the first and third most amount of money out of any state in the country. If you want to fix that problem, you should be able to go in and say, hey, I'll make you a deal. I'll come in, I'll fix the infrastructure in order to make that work. But on the other end, this is the deal that we're going to make about who gets what.
The idea, yeah, we have the money. We're going to pay for our rights to have at it. Should be what makes this decision.
Exactly. And I'm pretty sure they can, put a provision in there to where, if they ever go through a drought or whatnot, then, the state of Texas will be obligated to send whatever they need, whatever resources that they need over there to get that taken care of. Because I know they can afford it.
And part of the compact is they can buy up to X percentage of the rights to having all this.
Mm-hmm. Right. But anyways, I just wanted to get away from politics for a second. I thought that was a pretty funny, pretty funny ruling finally after 100 years. But just to conclude, Chevron deference and presidential immunity case goes hand in hand. All right. Because while the president has more constitutional authority within his branch, his agencies, on the other hand, have the hard ceiling and now have to hold the burden of proof.
The best things to come out of this Supreme Court session ever.
Yeah, literally. So now the people get to decide how the law is interpreted in outside of what we talked about before, the big business and the unelected bureaucrats. Now they get the bad part of the deal and they can go kick rocks because it kneecaps all the federal agencies, therefore putting a ceiling on the executive branch. So for all of you out there that like to play Supreme Court from home, why don't you leave these decisions to the professionals, shall we?
Hey, I have no problems breaking down and analyzing the decisions and what it actually means, but it has to come from a place of honesty and being rational.
Right.
I have to be able to look at both sides. I understand in many of these cases with the regulations that have passed, they probably did the right thing. It's just how they went about doing it that was wrong.
Exactly.